Alrighty, good evening, everyone. Welcome to week 9 of administrative law. Big couple of weeks, as many of you would know, with the whole Djokovic case and everything. It's not every day that you see your admin law unit concepts plastered across the front page of Facebook or the newspaper or whatever. So that's kind of cool, and we'll spend a little bit of time talking about that in a moment. But our key topic for this week is procedural fairness and natural justice, and that was a topic that came up in the Djokovic case as well, which is really cool. A few little things, a little bit to housekeeping before we do get underway. The first thing being your midterm assessment marks. I'm 2/3 of the way through those, so that's all coming along really well. I'll have those. I think at the moment I'll get those back to you on Thursday. If things go really well, it could be Wednesday. If the last few take a little bit longer than I'm expecting, it might be Friday, but certainly Friday will be the latest that you'll have those marks back. So yeah, those are not too far away. We're really sort of kicking into gear thinking about the take-home exam as well now. So in case you haven't seen, that date has been released. It's up on Moodle and a few other places, but the date for that is Wednesday, the 16th of February, and it runs for 6 hours from 3 p.m. until 9 p.m. Queensland time. So, now's the time to sort of start thinking about making arrangements to sit that exam at that time. And we've been doing a bit of exam prep already, but now we really kick into gear over these next few weeks, thinking about, what's expected in the exam. How do you go about preparing yourself and, giving yourself the best chance possible to do well on that exam. And so really what my advice to you at this point in the term is to be as best as you can. And I understand that, there's a lot of other subjects have got assignments due at this point and things like that. So, I'm not making wild demands or anything. You do what you can, but as much as you're able to, making sure that you're taking really detailed notes as we go will save you a lot of time trying to study and pull everything together into study week and in your exam preparation. So really trying to, and this is a lot of what we try and do in these tutorials, is think about, how do we take all these ideas and concepts and bits of legislation, and how do we structure those into an answer? And what I would like you to be able to do through a combination of these tutorials and your own study is to have a bit of a sort of a template for yourself of how you would go about answering a question on or a response that involves natural justice or unauthorized decision making, whatever the ground of review is. Ideally, the place that you want to sort of get to is, once you identify a ground of review that's relevant, you want to have the skeleton of what that answer is going to look like, and then you're just plugging in the application of each relevant fact and what's going on. So, and I'll talk through in a fair bit of detail today about how you step through that for procedural fairness. And I think I've tried to be pretty clear in previous weeks as well about how you can do things, but over the next few weeks we really carefully step through what these answers should look like, what's going in, why it's going in, and how you sort of craft that answer, so that, yeah, by the time you do that exam, your notes are well enough prepared that you don't even really have to think about any of that stuff. It's all just almost automatic, and it's about putting in the detail and the critical analysis that's really important as well. But before we get into today's topic of procedural fairness, I thought we should spend a couple of minutes addressing the big headline of the Djokovic case. I know on Teams, a lot of you were quite eagerly watching proceedings and yeah, thinking about what's going on and how that relates back to some of the ideas that we've been talking about in this unit. So I suppose one of the key things, and I'm really keen to open this up to you guys, but one thing that I do want to say in the beginning is one thing that I'm really keen for you guys to take away from this case is hopefully, as you were reading through it, as you were watching proceedings, sort of however you were engaging with it, the really key thing was that the judges were not looking at should Djokovic's visa be cancelled in and of itself, right? They're not thinking about the substance of the decision in the sense of, oh, what's the right decision in here? Should he be allowed to stay or should he have to go? Their focus was always on the process by which the decision was reached. How did the minister arrive at this decision to cancel the visa? The statute, section 133 of the Migration Act, sets out quite clearly what the minister has to do. Did he do those things? And if so, the decision's fine. If there's a problem, the decision is problematic and we get rid of it. That was the key focus. And I hope that, the thing that I most want you guys to take away from this case is that really interesting distinction that we see in judicial review. The focus is on the process by which the decision is reached, not on whether the right decision was reached in substance. Was that something that stood out to you guys as you kind of saw things play out over the last few days and weeks?
What was interesting, Jacob, and everybody, that the Chief Justice, in basically handing down the decision, made made some mention of that in light of the fact that many people watching or engaging from within Australia and overseas probably wouldn't have understood it. So I noticed that he made a little, I can't remember exactly how he framed it, but he did make a comment in relation to the, fundamentally what we're talking about, that it was the process of the decision, not the decision itself. It was not about was the decision right, but was the process correct, and more the scope of what the review was about.
Yeah, absolutely. And it's been quite interesting. I mostly use Twitter in a very sort of sheltered academic world, but it's been interesting the number of sort of administrative lawyers and administrative law lecturers sort of jumping on Twitter and complaining about people not knowing the difference between judicial review and merits review and all that sort of stuff. And it's you're right, there was such a big interest in the case that it was really important to highlight that distinction. What were some other people's reactions or thoughts, either about the sort of narrow idea of judicial review or just sort of more broad reactions to the case?
I think I was quite interested with the manipulation of the outcome, knowing that obviously it was a judicial review, etc., but then looking at the media and that the way they played it was, it was the wrong decision, it was this. And you've seen people like John McEnroe and all that today, again, coming out on those grounds and not really understanding the legal context of what actually happened. That was what I found very fascinating.
Yeah, there is this, and this was sort of inevitable given the profile of the case, but the political dimension to this as well is really fascinating. The way that, if you want to be cynical, you could call it a dead cat strategy or something, but the way that there has been this, it's been used as sort of a political tool and a subject for political debate has, I think, really highlights, obviously, not every administrative law case is this political, but fundamentally every administrative decision has a political element to it. And this case sort of really highlights what's always latently there. Absolutely. So Christy, you were going to say something, and then Hawara, you had your hand up.
I guess for me, one thing that really struck me was how they both presented themselves and how they spoke. not even necessarily the content of what they were saying, but it seemed that Mr. Woods was nervous and fumbling, and he just went over and over and over the one point because he didn't really have anything else to say. Whereas Mr. Why do I think Taylor? Lloyd was really confident. His body language, he knew, he seemed to, I thought that was interesting, at least for me, to see how they presented themselves, how they spoke to the justices. Yeah, he also didn't seem to be fumbling with pieces of paper. So I felt like perhaps he felt that he had a better case, or his points were more succinct. Yeah, I don't know.
Yeah,
that was
yeah.
my
No,
take.
it's I mean, that's the great thing about getting to see these proceedings and being able to identify those differences. That is that, you know, if that's something that, you know, if that's a career path that you're hoping to go down, identifying, you know, a model of what is good or something to aspire to versus something that you sort of hope to you know, I don't think it's entirely possible to avoid the nervous phase, but, you know, at least get through it fairly quickly. Definitely. Huara.
For me, I didn't go really deep into this because I've been catching up with studies. But,
Yeah, of course.
I want to say in general, like, it was cool to just say like what was said on the news, and then I was putting my study law hat. I say, okay, let's go to LexisNexis. Let's look at the case, what's been published, and the fact that was there, and then what they really explain, as Michael said, the judicial review. And then what got me was the use of the case. So I can see that they used the Minister for Immigration and Multicultural Affairs. Like, I could see, like, I could highlight basically everything that we've been studying. So for me, I just, want to say it was very cool. Just back to reality that what we're doing is actually real and judges are using what we're studying. So it was pretty cool.
Yeah, it is.
And in relation to the case, just one last thing, it made me just realize about the powers of the government, if that makes sense, like the separation of power thing. Especially like me, people that have been going through visas and stuff, that make you realize like how big is the power. And there were 2 sentences on the report that make me think that they say that, like, we're not thinking about what's a fair decision, we're just thinking the error of law. So that's pretty much what we're studying for. And then that's like another thing was that got me was if this was like, there was a need of more time to actually think of what was the right decision, that basically they put it up to say that this was not as urgent decision to like immediately change what's going on. They didn't see any reason for actually changing what was decided because that's not urgent, it's still a game. And pretty much, I don't know, that's what it got me, like those 2 points.
Yeah, absolutely. And the power element, I think, is interesting in 2 senses. First, there's the separation of powers element that you've pointed to, and the way that feeds into sort of the limits of judicial review and how far we're willing to go with this stuff, but also just the sheer breadth of power. And you know, migration law is not necessarily typical. It's quite exceptional in a lot of ways because it is such a politicized area, but just the absolute scope and flexibility of the minister's power, and you know, it's not quite a blank check, but it's not far off it in terms of giving the minister power to make a decision, and to make basically any decision. It's pretty much as broad as ministerial power gets, and so it's a really interesting example. It's an extreme example, but I think it does quite nicely highlight, I suppose, the stakes for us as you know, administrative lawyers, in terms of thinking about the government's capacity to exercise power over individuals and to influence, you know, pretty key elements of their lives. and the way that administrative law tries to function and keep that power in check is yeah, absolutely really interesting. Definitely. I'll just catch up. There's a few points in the chat as well. Was interesting to read the original submission documents. The thing that really got me was the original submission documents. Yes, the original transcript from when he was sort of first stopped at the airport and the initial decision was made. If you haven't read that, it's not a short read, but you can skim through elements of it. But that was what really got me, because that, I think, more than anything else, really highlights the scope of executive power in this sort of immigration context, and it, you can just sort of tell from the transcript the way that the officers kind of speak and the power that they know that they can wield, and you sort of think, here's a guy who is at least somewhat familiar with the process and what's going on, has a reasonable command of English, and is fairly assertive. He's obviously a competitor. He's willing to stand up for himself, and yet in this context at 4 a.m. in the morning, he's completely on the back foot. And it just sort of makes you think, for people who don't have those advantages, what that context and what that situation would be like is yeah, pretty it's a deep thing to be thinking about, certainly. So if you've got the time, I'd encourage you to read that transcript, and I can put it up on Teams and Moodle as well, because yeah, I think it really highlights the scope of the power that we're thinking about in this unit. Kelly's asked, was there a special power to allow the matter to be heard on the weekend? Yeah, so basically, the federal court has its own what's the word, sort of power to determine its own proceedings and to run itself how it sees fit to an extent. And so basic, and this is another thing that's quite atypical about this case, is that you do not usually get a full federal court sitting on a Sunday. So it's it's fairly exceptional, but yeah, the court's power to determine its own rules of procedure, and it's that was organized to sort of expedite things, especially in the context of, one way or another, there needed to be certainty for today, because that's when the Australian Open starts and stuff like that. That's sort of what has enabled this. And yeah, it's not, certainly not something that we would regularly expect to see by any means. I'm conscious that we do still have a fair bit of regular content to get through, but are there any other sort of initial thoughts, comments, observations about the case? I'll be pulling a few other examples from it over the next few weeks as we dive into other topics that were sort of raised or are relevant. I'll sort of, oh, you remember in Djokovic when they said this and stuff like that too. So it'll be the gift that keeps on giving, I think. But yeah, we'll press onwards for now and think about procedural fairness and natural justice, which is our key kind of ground of review for this week. And in terms of thinking about this topic from the view of stepping through an answer, quite, I suppose, pragmatically, the two key kind of questions that you want to be thinking about and that you want to be able to answer is, first, when does procedural fairness apply? And then, within that, we're thinking about the strict provision under Section 5(1)(a) about there being a ground of review where there's a breach of the rules of natural justice or procedural fairness. And then the comments in Kiowa and West, particularly wasn't Chief Justice at the time, he was just regular Justice Mason, saying 5.1a doesn't itself create an expectation of procedural fairness. It just says that, if you can find it elsewhere, it's a problem if you don't get it. But then also Justice Brennan in Kiowa and West saying there's a presumption at common law that you will get procedural fairness, natural justice. So being able in an answer to step through the elements of identifying when procedural fairness will apply. First off, there's not a requirement that it apply, but there's a common law presumption. And if we don't see anything else that is contrary to that, then we can expect that procedural fairness should apply. And if we don't get it, then 5.1a tells us that that's a problem. So that would be sort of the third thing. Now, the reason that that is relevant, and this is why the Djokovic case is quite interesting, is because the Migration Act is one of these interesting exceptions that sort of rebuts the presumption of natural justice. It sort of specifically in relation to the minister's sort of discretionary power under section 133C. 133C4 says that the minister doesn't have to give natural justice when making a decision under section 133C3. So this was one of those kind of quite rare instances where Parliament has explicitly excluded natural justice and has explicitly rebutted the presumption at common law that you will get natural justice. So it's not a common thing, but it does quite nicely highlight that it does occur. And that's why it is important for us to be able to step through and establish that if we are looking at a procedural fairness ground of review, that we do have, we are entitled to expect procedural fairness when a decision is made. So just being able to identify that, I think, has quite nicely been highlighted while that's relevant. So first step, does it apply? Usually the answer is going to be yes. As we've seen, sometimes the answer is no. But if it does apply, then the next question is to think about, what does procedural fairness include or demand? What's the content of procedural fairness? And this is, according to Justice Mason, and I think he's probably right in this, this is actually the more important question. I think we tend to, well, there's a temptation to get hung up on, does it apply? But really, in most cases, it will apply. And so it's important that you deal with it, but you can deal with it fairly quickly. And then what's really important is to think about, okay, well, what does natural justice or procedural fairness look like in this scenario? And that's something that's really emphasized in Kiowa and West, is it depends on the context. We have some general rules about, the hearing rule and the rule against bias. Those are general expectations, and those would usually arise. But really what we're wanting to do is look at the exact circumstances of the particular case, and really think through quite carefully what does, given sort of everything that's going on, what would procedural fairness look like? What would actually be a fair way of processing through these this decision? And so I think Huaria has got the quote here. It depends on the circumstances of the case, and they'll include inter alia, the nature of the inquiry, the subject matter, and the rules under which the decision maker is acting. Absolutely, yeah. So it's really important that you, and this is the hint, the big hint for the exam. It's really important that you're not just able to identify, oh, okay, we would expect procedural fairness here and they didn't get it, therefore it's a problem, therefore the decision should be quashed, all that sort of stuff. You need to actually be able to think about in some detail, okay, what would actually be procedurally fair in this case, and was that delivered? So my suggestion when you're sort of doing out your little answer plan is to leave yourself a note to just sort of stop for a minute and think, okay, what, in the context of everything, what would procedural fairness look like here? And then, then you go on and you do the rest of the stuff. So we've obviously got the hearing rule. So, and we'll talk through some of the detail of that when we get through the tutorial, the hypothetical questions, but, thinking about basically an opportunity to be heard and an opportunity to comment on the substance on which the decision is going to be made, and the rule against bias. Again, reasonably straightforward. We would expect that the decision maker shouldn't be biased when they're making their decision. The other sort of thing to note about kind of the content of procedural fairness and the context is that, yes, we want to focus on the context of the case, of course, but on the flip side, we want to be careful about the court's role here. And this sort of ties into these broader ideas about the limits of judicial review that we've been talking about. The goal isn't so much to set up what kind of the ideal standard would look like, and then if there's a variation from that, then it's a problem. I'd say that usually that would be going a little bit too far and stretching the court's role a little bit too far. Instead, we're looking for something a bit more general, a bit more maybe flexible, and sort of thinking about in sort of broader terms, what are the kinds of things that we would expect here? What sorts of actions or opportunities would you expect the decision maker to afford the affected person? And how were those achieved or not achieved? What was the impact on the person who's been affected? And was that impact procedurally fair or not? So we're not looking to, and a good example of this might be, we would expect that a decision maker would give someone an opportunity to comment on the information that the decision is going to be based on, as sort of a broad principle under that hearing rule. We might think if they were given, if they were given half an hour to comment, then maybe they probably weren't given genuinely enough time to make a fair comment, and that might not be procedurally fair. But the flip side wouldn't be, oh, well, they need to have 60 days or 90 days to prepare a response. And if they were only given 59 days or 89 days, then that's not good enough and that's not procedurally fair. We're not looking to impose something that extreme or that definitive. Instead, we're just sort of saying, look, in the context of everything, could you have given this person enough time to actually, say something worthwhile and genuinely engage with what's going on? And that, might be contextual. That might be something that, the decision needs to be made fairly quickly, or it might be something where you would expect someone to have a little bit more time, consult with a lawyer or whatever, and then get back to you. And so the key point that I'm making here is don't be trying to set out a really explicit, they should have, given them 50 days in writing, opportunity to speak to their lawyer, and they weren't given all that gold standard, therefore it must automatically be a breach of procedural fairness. You look at it and you say, okay, did they have a genuine opportunity to engage with this information and to comment on it? Yes or no? So a bit more broad, a bit more flexible, but nevertheless quite targeted to what's going on. Does that make sense? Cool. Well, we'll see that sort of in action here. And I think that will sort of make things a little bit more concrete. So we'll start off with question 1. We won't have time to get through all the questions tonight, but that's okay because a lot of them are sort of double ups from other weeks. But so our first question, we're sort of revisiting the scenario from week 7 with the gaming and casino. And so this was the scenario where you're not allowed alcohol in the gaming area. The officer came over and saw that people had been allowed to bring alcohol in, and so they went through and gave them a notice and wanted to terminate some of the employees and things like that. And so we've already talked about why that decision might have been problematic from the perspective of sort of authorized decision-making and unauthorized decision-making. Now what we're looking to do is to say, okay, was this also potentially problematic from the perspective of procedural fairness? And so, as always, I'll open the floor up for a little bit. We can discuss some of the ideas, and then we'll start to think about how we pull that together into an answer.
So for my approach to these questions, the first question I will ask whether the party have a standing to be views. So of course they have an interest to be views because that is affects their appointment. So they have a standing for, that's my first question.
Yep.
So the second question, I will ask whether the statutes have any explicit language to deny the procedural fairness, and no, there's none. So it may be giving me a signal that's a positive to natural justice. And then I will run through each of the factors under the word cover, Corporation of South Australia 2011, and apply in the present cases to see whether that's factor are there. So for example, the first question will be asked, is the original decision is the preliminary or final one? And the current one is the final decision. So it's a pass to the natural justice. I will think it like that. And then second question will be asked whether the original decision is made in public or private situation. And this one is made in the private. So it's maybe a negative to the natural justice. And then the next factor will be asked whether there is any formal procedure that the decision maker has to comply for. So the section 26 say that the decision maker may conduct the inquiry to find out whether there's any ground for discipline. So the word may here give me a reservations like it may be a negative to natural justice. And then I go further to other factors like, can I continue? Sorry. So yeah, like the next question is whether the decision is of a urgent nature. No, it's not urgent. So it may be positive to the natural justice in this case. And then the next question is whether the appellate body is the judicial, internal, or domestic. And because it can be the AAT review, so it's a positive to natural justice again. And then the next question will be asked like whether there's any appeal avenue available. And yes, AAT reviews will be de novo. So the natural justice may be negative in this situation. And then the last factor will be whether the natures of the interest and consequence for the individuals and subject matter. The party has interest of decision to affect their employment. So it's a positive to natural justice. So I found out that is actually 5 positive to natural justice and 3 negative to natural justice. So I conclude that natural justice is available in this case. Yeah.
Awesome. Very nicely done. Very thorough. I like it. So yeah, so I think it's really great to work through those ideas from the work cover case. I think I wouldn't necessarily use it as a checklist in terms of simply on the raw numbers, are there more factors for rather than against? But I think that in this case, you're absolutely right that when we consider these kinds of factors, what they point to is a scenario where natural justice is probably going to be important. And I think even more usefully, it starts to give us a picture of what the content of the procedural fairness should be looking like. And so, we can step through the kind of process that I've outlined before in terms of thinking about when does procedural fairness apply. Justice Mason's comment that it doesn't apply if there's no requirement from somewhere else. Follow that up immediately with Justice Brennan saying there's a presumption at common law, that's your somewhere else, unless we hear anything to the contrary. As Maggie says, as far as we can tell, the Act doesn't explicitly deny procedural fairness. So I think that, that common law presumption stands in this instance. So we know that procedural fairness applies, and under Section 5(1)(a), therefore we would, be able to ask for a judicial review if there is a breach of the rules of procedural fairness. So I think in terms of identifying whether we can get procedural fairness or not, pretty clearly we would in this instance. And then what we can really usefully do in terms of thinking about work cover is drilling down into that in a little bit more detail. So, as Maggie says, this is a final decision that's being made, fairly privately, but nevertheless is not necessarily secret either. There are some formalities set out in Section 26, but in other instances, there's a little bit of flexibility. Not urgent, that's a big one. I think that, where a decision needs to be made urgently, that is a really big, it doesn't necessarily mean that procedural fairness doesn't arise, but it certainly, in terms of thinking about the content and the context, certainly quite significantly narrows the scope of what we would expect procedural fairness to include. And so, yeah, I think stepping through those pieces of work cover, those sort of points, is a really great way.
Can I just stop you before you move on?
Yeah, of course.
Point?
Yeah.
Because that one point confused me. You were talking about whether it was the speed, or I can't think of the term,
urgency,
how quickly it was going through.
Mm-hmm.
Does that mean that in this case where these guys had to be terminated as part of the thing, that would bring into question, that would sort of say that there is grounds, because it is such a quick decision that's got to be made, because saying they've got to be terminated because otherwise your license is at risk. So would that not be, unfair?
It's a tricky one, right? And this is why I'm saying that I think that really what this is important to think about is not only using it in terms of does procedural fairness arise, but how do we understand the context and therefore what procedural fairness would demand. And urgency, you can certainly make the argument that where a decision is being made quite urgently, the urgency of it demands that you do things in a very clear and deliberate way so that people aren't kind of disadvantaged by the speed at which the decision is made necessarily. If a decision has to be made quickly, arguably it's more important that that the decision maker is making the decision on correct information, and therefore the person should have the opportunity to correct the record, that sort of stuff. So you could use urgency as an argument, I suppose, in favor of natural justice, or to sort of shed light on what the content of the natural justice should be. But I think that urgency is more powerfully used in a situation where the decision is not urgent, because there's less reason to deny someone procedural fairness, right? It might be that a decision has to be made really quickly for whatever reason, and because the decision has to be made really quickly, you don't have the opportunity to consult with them about the decision first and to give them that hearing under the hearing rule, let's say. Whereas in something like this, where he went in, he had a look around, he saw that there was this problem, he went back away, he typed up the letter outlining what the decision was, and gave the notice. I don't think we get an exact timeline in terms of how long that is, but it's not an instantaneous thing. And so therefore, if there was this time period, then why would you not give Poe and Rue the opportunity to comment on the information? Why would you not give them this procedural fairness to respond to the information, to have their say, all that sort of stuff? And so what I'm saying is that urgency of a decision, if it was, if he walked in there and there was, I don't know, it wasn't just alcohol, there was all manner of drugs, there was, a gang shootout in the middle of the pokey bar or something, and he just went, wow, this place is so out of control, this place is so crazy, we just, in the interest of safety, I need to shut this down right here, right now. That might be something where urgency doesn't demand that you afford procedural fairness or natural justice, because it's like, the safety of everyone, that's the reason for the decision, and that takes precedence over these guys' right to employment or whatever. Whereas where it's not laid back, but where the timeline is stretched out a bit, it's harder to make the argument that this was an urgent decision and I didn't have time to give this person a hearing and prior notice that the decision would be made, and all those sorts of things in terms of the content of the hearing rule. So I can definitely see where you're coming from, right? The urgency in itself can go either way, which is why we need to consider the full context of their case and the decision. But what I would suggest is that urgency will be most useful when you're arguing that this wasn't an urgent decision, therefore we should have been given natural justice or procedural fairness. Does that make sense?
Yes.
Yeah, it does.
Cool.
Yeah, actually, in our study guide and the textbook, they have less explanations about the urgent nature. So that's why I have some research by myself.
Mm-hmm.
Immediately, those, and also what else, like the power to arrest some people for smuggling, all those things. So those kind of situations will be considered as urgency. It's not about the decision has to be made immediately.
Yeah, absolutely. So yeah, the sort of the significance of of the decision, and then the impact and kind of what it is a key part to this as well. Definitely. Excellent. All righty. So I think one other thing I sort of will clarify as well is just in terms of thinking about some of the references to the AAT. A couple of weeks when this sort of arose last time, we established that on this particular issue with this particular decision, merits review via the AAT wouldn't be available, and that's because of the exact section. So section 41 of the Act says that the AAT can look at a refusal, issuing or suspending a license. But then this decision is neither of those things. It's a requirement that the licensee comply with a thing. So in this particular instance, we wouldn't expect merits review or the AAT to be able to review this. But I think on balance, and this is why I'm sort of suggesting that it's very useful to go through these ideas in work cover, but it doesn't necessarily have to be a really formal checklist. I don't think that would be a barrier to arguing that natural justice applies here, or to arguing the content of what that should look like in this instance. But I did just sort of want to clarify in case anyone was wondering about that as well. But yeah, really good stuff. I think, we've sort of covered quite clearly that procedural fairness will apply. In terms of thinking about the content, clearly sort of what we're all getting at here is the hearing rule. And in particular, thinking about notice that a decision is going to be made, a disclosure or an outline of the substance of the information on which the decision is going to be made. So, hi, I went into the casino, I saw people with alcohol when they shouldn't have. And then really key, being given the opportunity to comment on that information. And so what we're thinking about here, and this gets to a lot of the stuff that's already been covered, but really those three things being the broad content of what the hearing rule would demand. And in most instances, that would be, a fair thing to expect for procedural fairness. None of those things happened as far as we can tell, right? As far as we know, the first that Rude knew about this was when she got the letter saying, I've been in it, there's a problem, you need to terminate these guys' employment. And so what you're doing here is you're arguing that she should have been made aware that the disciplinary inquiry was taking place. Obviously, she got the notice that it would be, or we're assuming that she got the notice that it was going to take place. I think that's section 26.3. They have to provide at least 28 days notice that the inquiry will take place. We don't know on the facts whether that was actually complied with or not. If not, then that's sort of another problem and sort of another point in favor of procedural fairness not being delivered in this instance. But even if it was, there was no sort of really clear discussion as far as we can tell that the actual investigation took place. And then certainly no opportunity to consider the grounds or the evidence that was being used in the decision, and no opportunity to comment on that. And so, that's relevant. And in terms of pulling together an answer, this is a little bit similar to the midterm where I've said, you can be a little bit speculative to a point, and where the facts kind of indicate to you that there's kind of grounds to kind of go down the path a little bit, you can, but you just don't go too far. But in this scenario, it would be important for the people who are affected to have an opportunity to comment on that information, because there might be, you know, a quite a reasonable explanation for why there was alcohol in the gaming area when it shouldn't have been. And you know, you can be a little bit creative about what that would be, but the point is to highlight that it was important that they be given the opportunity to comment, and they weren't, and that not being able to, not having that opportunity to comment on the evidence has adversely affected their interests in the outcome of the decision. So, as I said, you know, you don't go wild with that, but highlighting that there has actually been a real consequence from the breach of natural justice it goes a long way to actually demonstrating that it is a problem and it is an error that invalidates the decision. I'll just catch up on the chat. Okay, cool. I can do a little bit of stuff on the urgent nature as well, although I think I've sort of said everything that I think I want you to know about just now, but if there's a feeling that there could be, you know, it would be good to have a little bit more detail on the urgent nature stuff and procedural fairness. I can type something up for sure. The only other thing that I'd add then, sort of in wrapping up this answer, is that just to sort of come back to what I was saying earlier about being quite clear or conscious about the limits of the court's role in all of this. What we're not doing in sort of setting out, this is what procedural fairness would demand that that Poe and Rue be informed that there's going to be the decision, told about the evidence, being given an opportunity to comment on the evidence. In saying that, we're not dictating exactly how the inquiry should have taken place. We're not, for example, saying under section 26(4) that that the officer should have announced themselves, because quite clearly they don't have to do that. We're not dictating a time frame by which they, we're not saying she should have been given 28 days to comment or 30 days to comment. We're not being that sort of fixed. We're not dictating that they should have been given the chance to rebut the conclusion, and we're not challenging the outcome of the decision. We're saying that the procedure by which the decision was reached was unfair, and that they should have been given an opportunity to comment on the evidence that the officer had before the officer made that decision. And that's the problem that we're identifying with this decision. Does that make sense? Cool. We are going to run out of time to sort of dive into any of the other questions, but I'm sort of okay with that, because that's the major question, and that question really highlights the key things that I want you to really get out of the procedural fairness stuff, and in terms of structuring a procedural fairness answer. The only other big sort of thing that comes out of later questions is the rule against bias. And the key things that I really want you to take away from that, it's a little bit more straightforward, because we've got, because we've got the scope for apprehended or perceived bias. It really opens things up a lot and gives us a lot more flexibility with this argument. So I would suggest to you, in that any question where we think that there might be biased, really just pull out the general test from LAWS and ABT that a fair-minded person might reasonably suspect that the decision maker might not resolve the issue with a fair and unprejudiced mind. So, there's lots of mights and maybes and reasonables and stuff there. So that's a lot of flexibility for argument. And then Gleason and Gummo in GIA, the question is not whether a decision maker's mind is blank, it's whether it's open to persuasion. Pulling out those two kind of ideas and standards gives you a lot of leeway to sort of argue, look, we're not saying that this person had completely made up their mind, and we're not also saying that they should have had a completely blank mind. What we're saying is that they weren't open to another point of view. They don't seem to have been open to other arguments, and or there's some factor here, there's some interest or something that they've said previously that would lead a fair-minded person to think they're not coming into this with a fair and unprejudiced mind. And there's a little bit of it's open to argument here, and as has been said in the chat, there's it can be a little bit hard to prove, certainly. But what I'm suggesting to you, especially from a perspective of a hypothetical assessment, is that it's a good thing because it gives you scope to make a persuasive argument, make a case. Briefly in the chat, may I ask what the difference between actual and apprehended bias, and how does each of them affect their argument of natural justice? Basically, the difference between actual and apprehended bias is, actual bias is where you need some pretty concrete or hard evidence that this person is actually biased. And so, that might be, somehow you get the case file and they've, written themselves a note or something saying, oh, I hate this person, and so of course I'm going to rule against them, or, something really concrete that shows that the person is like definitely biased. It's really hard to prove. Apprehended is broader and invokes that sort of flexibility around, you don't have to necessarily show that they were biased. You have to show that a fair-minded person might think that they're biased. So it's more about perception and things like that. I realized that I may have just frozen there. So I'll rewind a little bit because I'm not sort of sure when I dropped out then, but actual bias, you need sort of concrete proof that this person is like genuinely prejudiced or does not have an open mind. They've made up their mind about the decision before the case, whatever it is. Apprehended bias, more open, more flexible. And the sort of standard here is that would a fair-minded person think that they were biased? It's more about perception. Does this person appear to resolve it in a fair-minded manner, or do they appear not to resolve it in a fair-minded manner? And yeah, that's a little bit easier to prove. You can sort of think of it as sort of little dots in terms of facts. You've got lots of little dots. Apprehended bias, you can kind of sort of just pencil in how the dots kind of connect to each other, and that's enough to sort of show, gee, yeah, this looks a little bit dodgy. Whereas with actual bias, you need, a really hard connecting line between the dots to show, yeah, this is actually like a real problem. I think that's the simplest way to sort of think about the difference between the two. And, actual bias, from an evidentiary perspective, actual bias is hard. Apprehended bias is a little bit more easier. So it's worth thinking about that one more heavily, I suppose. And it's worth sort of really, and especially in terms of the cases as well, thinking about how those really tie in. Does that make sense?
Yes, thank you.
Perfect. All righty. I will have to call it there because I've got another class to run off and teach, I'm afraid. If you do have other questions, especially about those hypothetical problems that we didn't get to, please do, jump on Teams, Moodle, email, however, get in touch, and I'm more than happy to jump through that. And yeah, other than that, your quizzes are open for the next week, so jump in and do those when you get a moment. And yeah, we'll be back next week to talk about our final ground of review, which is unreasonableness, which played a big role in the Djokovic case as well. So we'll be talking about that again next week. But yeah, really looking forward to it. Thanks everyone for coming along. I'll see you next week. Bye.